Next up is Jessie Zeigler, a trial lawyer at Nashville's Bass, Berry & Sims. Jessie is the assistant practice leader for the firm's Products, Torts, and Insurance Group, as well as the co-chair of the firm's Food and Beverage Industry Group. Jessie has experience in environmental litigation, mass tort, and contamination cases, among other areas. She recently won an appeal in the Sixth Circuit Court of Appeals, shooting down an 11th Amendment sovereign immunity claim of a municipal gas authority, potentially worth many millions of dollars, to her client and others similarly situated. Please welcome Jessie Zeigler.
Good morning, everyone. It is great to be back here at the New York Bar Association. Last week, I had my 13-year-old daughter in my office, and she was looking at a plaque that I had on the wall that said Nashville Bar Association. And only in the way a teenager can do, she looked at me with that look of disapproval and said, "Mom, what are you doing with an award from a bar association?" So this is what she was thinking. And so I explained to her about the legal bar and what it is, how the term dates back to a time long ago in England when students would sit on one side of a physical bar and lawyers, the barristers, would sit on the other side until the students eventually passed their exams and finished their studies and were admitted to the bar on the other side. So today we're going to talk about how we, as members of the Bar Association, are going to take that bar and raise it high so that we can serve our clients well and apply some creative thinking and operating from a position of strength when we tackle a new matter that we have for a client. Who here has ever been hit with a spoliation motion? Just a few of you. And who here has ever filed a spoliation motion? Okay, so it's actually not as common as you would think. I've been practicing 20 years, and I hate to say this because I'm going to jinx myself, but I've never been hit with one. I've never had to file one, but that doesn't mean that it doesn't govern my every step as I walk through the matters that I work on for my clients. And I am sure as you tackle your matters for your clients, it affects everything that you think about as well. So as you know, spoliation is the alteration or destruction of relevant evidence. It can be intentional, which I'm sure none of us would do, but it can be unintentional, and that is what sometimes paralyzes attorneys and does not help us think creatively and take actions that can really and truly lead to superior results for our clients. And that's because we're fearful of the sanctions. And courts apply a large variety of sanctions if there is a spoliation motion that is well taken, the worst of which is an adverse inference that jury instruction, where a jury is instructed that that destruction of evidence or just the lack of evidence, if it's missing, that it would have been harmful to your case if it were produced or present. The sanctions can also include a preclusion of evidence or preclusion of testimony. Part of your pleading might get stricken. Discovery could be reopened, or there could be monetary sanctions imposed. The factors that courts apply really do, they look at the bad faith or the intent, they look at the prejudice to the party, they consider how important is that evidence, whether prejudice can be cured without sanctions, and then the potential effects of the testimony regarding the evidence if the court were to allow it. But if you actually look at the case law on spoliation, there is a wide disparity of holdings and results. And even in the same jurisdiction, if you look at what state courts will do and you look at federal courts will do when faced with a motion, you'll see a wide variety of results and sanctions applied. And that's because significant discretion is granted to the court. If you are hit with one, know that if it's raised late in the game, that could be precluded. If you have a spoliation issue, you want to raise it early. So what's the good news? The good news, as I mentioned earlier, it's not as common as you would think to have these motions brought. The Federal Judicial Center recently conducted a survey and found that the majority of these motions are not granted. It was conducted at the request of the U.S. Advisory Committee on Civil Rules, who's considering whether or not there needs to be more uniformity brought through rules as to what sanctions are applied and when. And they found that half the cases reviewed involved electronic discovery. But that means about half the cases did not involve electronic discovery and involved physical evidence. 1/3 of the cases were tort cases, and about 1/3 were contracts cases, and 1/3 were just a variety of other kinds of cases. 30% of those motions were granted relief. So the vast majority of the motions that were brought were deemed not well taken by the court. And most of the time, 2/3 of the time, according to that survey, the plaintiff was the one who was bringing the spoliation motion. The bad news is, as we all know, litigation can be very expensive, and spoliation, just bringing a spoliation motion can add 10% to the cost of the litigation. I tell you this so that we think about it's important to be smart at every step of our representation of our clients and think through from the very beginning how we can avoid even having a frivolous motion brought against our clients for not preserving relevant evidence. So how does this apply to real life in your representation of your clients? Well, in real life, our clients have emergencies, and we are there to help them through those emergencies.
I'm Ziggler. Visit MilanFoundation.org and learn the facts. Let's change the future one job at a time.
You can save up to $3,000 a year.
Well, I hope I didn't just teach you how to steal data, but we can talk to David about that later. But the point is that it doesn't matter if you have a manufacturing plant or a corporate office. Emergencies take many forms, and that we all get involved in our clients' emergencies. I'm going to use the example today of the explosion. So whether it's a data breach or a corporate fire, you're going to need to think through how this applies when you're responding to an emergency. But in the context of something like an explosion, I'm going to walk you through the initial steps as to what you're thinking about and how you're representing your client. There's going to be multiple people involved in taking these steps. Not one person can do them all. But as we're doing this, we need to think through how we are collecting and we are preserving evidence, and we might even do testing and even destructive testing of that evidence long before litigation ever hits. And we'll talk about why that's true. The first thing you need to do is prevent another piece of litigation by securing the area. In an emergency, there's a lot of people rushing to the scene. Some might be family members of people who are in there, some might be media. Some might be other employees, and you want to prevent another problem. So secure your area. It also helps preserve the evidence and having people in there who might be taking anything that is important. You're going to need to notify the key people at your organization who need to be notified. You're going to notify any governmental authorities who might need to be notified. Is OSHA, do they need to be involved? Are there employees who are injured or killed? Was there a release of a chemical that might require reporting to EPA or another authority? And you're going to need to deal with the fact that your client right now has a public relations situation on its hands. So there needs to be somebody who's the public relations coordinator who is immediately designated to put the best face on this and all the efforts that the company has taken to investigate the situation. But you have evidence there. There's an emergency. There's witnesses. You might not have access to those witnesses after the heat of the moment. There could be contract employees, subcontract employees who you're not going to have access to later. So in the heat of the moment, think about how you can take witness statements and preserve that testimony for down the road. Consider taking photographs and videotape of the area that's affected so that if somebody says a certain piece of equipment was in a certain position, you can show that that in fact was not true. And there is a wide variety of evidence surrounding any kind of emergency scene that you'll have. And you need to collect it and preserve it. In the example of an explosion, for instance, think through just the immediate area. There's going to be lots of different pieces of debris and pieces of equipment that may have been involved in that explosion. And you're going to want to collect and bag every single piece of evidence that you can find and collect. You're going to want to think through the clothing that any injured employees were wearing. And once they're taken to an emergency responder, see if you can collect that and collect any personal protective equipment that they were wearing. But besides the immediate scene, you need to proactively think for your client, well, what else is out there that if I don't collect it now may not be preserved? There may be spare parts for that certain piece of equipment that were not used yet that are in storage that you're going to want to collect. And there might be servicing records for that equipment. So when you're collecting it, you are very carefully making a record of every piece of evidence that you collect. You're tagging it, you're labeling it, you're doing a chain of custody, and you're putting it in a secure area. And this is to protect you against any later concerns that evidence has been destroyed or altered or lost. As you're thinking through your emergency, though, you're also simultaneously, again, this is multiple people responding. It helps to have an incident emergency plan so that these steps are set forth ahead of time. You need to notify your counsel, notify your insurance companies who may be sending investigators out your way as well. We all know about placement of a litigation hold, critical in preserving the electronically stored information to avoid a spoliation motion. But we also need to remember that litigation is not yet filed, but that does not mean that we don't put the litigation hold notice down because we're on notice of an incident that is likely or could lead to litigation. And one thing that we need to remember is that we need to have reminders of that litigation hold sent every 6 to 12 months. Sending it out at the beginning, you might find 3 years into litigation that's eventually filed that somebody forgot and documents have not been preserved. So send out the reminders and, of course, have your press response prepared. You're collecting documents at the same time. You're thinking through what documents might be relevant to this that we have, not necessarily electronically stored information, but other types of documents. Are there contracts with any suppliers of equipment that was involved? Are there contracts with any contractors or subcontractors? Are there safety records? Are there policies or procedures of how the company went about inspecting the equipment and cleaning it? Process diagrams, permits. There's a variety of them. There might be photographs of the equipment or the area, before the incident occurred. And there might be videos, surveillance videos. So what your company may have surveillance videos, or you might have a surveillance video at your security station that becomes relevant to how quickly emergency responders got there and developing your timeline for litigation later. Hopefully you are retaining experts immediately to get out to the scene and be there quickly, and you're retaining them through counsel to try to protect any privilege that you can until they're designated down the road to testify. But when you have a witness at the scene and there's a government investigator there, or there's people from other companies there who are also investigating, and that witness is in front of them, they're necessarily disclosed. So think through having two different experts present at the scene, one who's behind the scenes, who's your true consulting expert advising your company, and one who's the fact expert who's out there collecting the evidence. For example, I had a client who had somebody killed inside a large piece of industrial equipment. Somebody needed to be trained in confined space entry to enter into that equipment after the incident and retrieve any personal protective equipment or other pieces of evidence that were inside this large industrial machine, and that was in the presence of OSHA. That expert necessarily was disclosed, but their role was limited to collection of evidence. And unintentional spoliation may occur if your expert doesn't know what they're doing. So they need to follow industry guidelines, and you need to make sure that they are adequately preserving and tagging the evidence. The most critical piece of advice I think I want to give you here today is, now what? The evidence is collected. What do you do with it? Do you just store it and do nothing with it until and unless litigation is filed? I suggest that you proactively think through how you keep that bar raised high, what you can do to really help your client. Your client's facing a PR issue, a government investigation potentially, employee relation issues, employees who are concerned that there might be a danger to them to continue to work because it's unknown what caused that explosion at that particular piece of equipment. You want to prevent another incident from happening. And you might be able to really determine that responsibility lies with another party, for instance, the manufacturer of a piece of equipment that was involved in that explosion. So you put everybody on notice. Anybody who was injured or their counsel, other component manufacturers, sellers, manufacturers, of a testing protocol that your expert has prepared. You send that out, and you videotape all the testing of the evidence, and you photograph all the testing of the evidence. And at the end of the day, you may find that you have an opinion from your expert that was not given in front of the others, that it was a defective product, for instance. And you could have that expert generate a report that ends up in no citations being issued by a governmental authority, ends up with a good PR outcome, protects your employees, and you have just really lifted the bar high in servicing your clients. And you can provide the data and the photographs and the videos that don't have the evidence conclusions to the other parties. And if a report is ultimately provided, you could do that as well. So in closing, you've preserved the evidence even while testing it. You've spoiled spoliation, you've raised the bar, and you've given superior service to your client. And if this was the last session, I could end this by saying the members of the bar can now go to the bar, but I'm afraid it's too early for that, so I'll just say thank you.